Welcome to Quantum Valuations FAST30 webinar. For those of you who don't know quantum valuations, we help organizations articulate, defend, and amplify intangible value, providing support for transactions, fundraising, tax, litigation, and IP strategy. And the goal of our FAST30 series is to share practical ways to grow enterprise value through better use of IP assets. Today's session will be recorded and you'll be sent a link. And please drop any questions as we go along into the Q&A panel, and we'll answer them at the end of the session. Today's topic focuses on what really drives patent value. And we're delighted to have Michael Caine as a guest. Michael is a principal and patent attorney at Davies, Collison Cave, practicing in the fields of chemistry, pharmaceuticals, and agri-chemicals. His professional standing is recognized by his role as Vice President of the International Federation of Patent Attorneys, as well as multiple professional awards. Shan's ideally placed to connect Michael's deep knowledge of patents to value creation. Jack is Managing Principal at Quantum Valuations, and in addition to being a chartered financial analyst, he is a registered patent attorney with a degree in mechatronics and Master of IP commercialization. Over to you, Jack and Michael.
Thank you, Tim, for the kind introduction. Hello, Michael. Thank you so much for your time and joining me today to talk about patent valuation. So today we'll talk about what actually determines whether a patent is worth something. Not in theory, but when a real decision's on the table. So Michael, before we get into valuation, when you hear the phrase patent value, what does that mean to you in practice?
Well, in practice, that means something different depending on the client I'm working for. So I do a lot of work for the big pharmaceutical sector, big pharmaceutical companies, and so patent value for them means something sort of quite specific. It means patent term. It means keeping generic companies off the market for as long as possible. That's value for them. For local clients, value could be helping them set up a new business venture. So quite sort of different, and I guess there's also a difference between, sort of the potential value and the actual realised value when the patent is actually providing the value. And so for some clients, there's a long time frame between the potential value being realised. So there's a continuum, I guess. But there's all that potential value at the start, and then we try to help our clients sort of work through to realise the actual value.
So clearly there's these legal aspects which underpin the intellectual property rights, and the commercial aspects, as you alluded to, with the size of the business, the type of the client, where they are in the life stages of the technology and their invention, which we'll get into all of that shortly. So some of the things, just from a practical standpoint, people tend to think about from a test of whether a patent is worth something is if you think about whether anyone in the market actually need to use these patents to cover a product or a process in order to operate in the market. And secondly, how hard it would be for a competitor to achieve the same commercial outcome without infringing the patent. So if a patent fails on both fronts, then it's not worth very much, regardless of what it costs to actually file and prosecute.
Yeah, fully agree with that.
So before we get into the details, I thought I would just quickly cover, by way of a very brief introduction, what we do when we evaluate a patent. We consider the legal, technical, and the commercial factors. So from a legal point of view, the things you want to look out for are how strong is the IP protection, whether there are viable workarounds, geographical coverage of the patent rights, ownership, are there any issues with ownership chain entitlements, and strategy, which we'll also get into in later on with this session. Then on the technical aspect, factors cover, usefulness of the technology, technical advantages and drawbacks compared with competition. Does it actually work? And if there are any regulatory hurdles, especially in the pharmaceutical space with clinical trials and FDA regulations. And then the commercial aspects sort of tie that together with whether any of the legal and technical aspects contribute to increased margins, lowering cost. If there are any execution risks in the amount of funding required, whether the client or the business has the distribution, the reach, whether the market actually exists and the market validation, the strategy of getting to that market, the ability for the company and the team to execute, and amongst other market factors. So the way we do this is, given all these factors, we'll look at appropriate valuation approach and modeling, and that's really translating the qualitative aspects of everything, the legal protections such as validity risk, enforcement risk, the claim scope, remaining protection term, and potentially infringement risks as well, and translating that into quantitative metrics such as royalty rates, discount rates, scenario weighted probabilities, margin sustainability, growth rates, useful economic life, and licensing optionality, to name a few, all of which need to be supported by and grounded in ultimately the legal and technical and commercial assessments, which we'll cover in our chat today. So that's just very briefly the valuation process, the lens through which we look at when assessing a patent or a family of patents. So Michael, for the benefit of the audience, please could you explain how patent protection works?
Right. Yeah, well, a patent is a sort of a short term, when I say short term, 20-year sort of right. It's a right to stop others from implementing your invention. It's not a right to actually perform your invention. There might be regulatory reasons why you can't actually perform your invention, but it gives you that right to exclude others for 20 years. It's grounded in a patent specification that includes a set of claims and also a description. So the claims are designed to set out the scope of protection, the boundaries of the protection being sought, or in the case of a patent, the protection that's been granted. And then the description part is designed to, enable the invention, as in include enough description so that someone, after the patent expires, can go ahead and implement the invention. But also it needs to have enough description in there and examples and demonstrations, I guess, to support, the scope of the claim. So both those aspects are important. Also important that the claims sort of meet the test for novelty, as in they cover something that's new that hasn't been done before, and also that is not obvious based on what has been done before. So there's all these sort of legal tests. It's got to be useful as well. It's got to do something useful. So when you think about a patent, it's this right that has to meet certain legal tests, and because of this, the claims, they can be have broad scope or be of narrow scope. If they're a broad scope, you need to have a lot more description, more examples to provide that support. If you've got something narrow, then perhaps you can get away with something less. So that's sort of the patent that we're going to be talking about.
And the claims you talk about, that's completely encased in language, in words, correct?
In words, yes, that's right. And someone reading patent claims for the first time might think, who are these guys, patent attorneys, coming up with this very strange, arcane language? But there's a bit of a language that goes along with patent claims.
So on the topic of not all patents are created equal, could you perhaps explain why that may be the case? Why two people, having ideas, and one patent for an idea could be a lot broader and more useful than another, and how that ties back to how the claims are constructed?
Yeah, so this is always a dilemma, when you're sitting down with the inventor trying to work out, how broad, to draft the claims. Because sometimes they can come to you with an invention that you can actually see could have really broad application, and with that potentially broader value. But in order to provide that description that I mentioned and that support, that might take a lot of money and effort, like generating enough examples, variations, showing that that sort of broad scope is sort of justified. So you sort of sit down with the client, and you need to have a good understanding of the budget, and what they can afford. And so sometimes you might go for a narrow filing, just because it'd be easier to get the support. Another possibility is to file two applications on the same day, one with a narrow disclosure and a narrow claim, and one with a broader disclosure. And then in 12 months' time, and that's what I should have mentioned before, with patents, that you get to file a patent application, normally in your home country, and then you have 12 months to file an international application or applications overseas. So in that 12 months, depending on how much work, extra work the inventor has been able to do, you can then make a decision whether you go with the narrow one or the broader one. So these are decisions that have got to be made sort of at the outset, and it depends again what the client is trying to achieve. And sometimes they will go for a broad scope because they want to attract the interest of a collaborator or someone who can invest, help them get further elaborate, expand their invention, and perhaps partner up. And perhaps that broader scope might make it more attractive, for a partner. So you might go with the broader one for that reason, knowing that in the end you might not get a claim granted. For that broad scope, you might have to settle for a narrow claim when the patent's ultimately granted. But there's lots of different scenarios that you have to take into account at that early stage.
Thanks, Mike. I'm sure the audience will appreciate this background context. Actually, this brings me to a case I'd like you to walk through with us, Michael, because it illustrates, this claim prosecution perfectly. That's the AstraZeneca formulation matter. Would you like to step us through that?
I will. I mean, it comes with a lot of pain talking about this case, but I'll work through it. But so this was a situation where AstraZeneca had a great statin drug that they licensed in from a Japanese company. And now the Japanese company didn't file the patent in Australia for the active agent. And I should mention, when it comes to pharmaceuticals, the patent covering the active agent is the one that is very rarely challenged by generic companies or third parties. Like they're often very difficult to knock out on the normal patentability grounds. So they're normally very strong patents, the ones on the active agents. So there wasn't a patent on the active agent in Australia, but there were these patents on a dosage regime for the drug that took some time and effort to sort of work out what that dose would be, and also a formulation where they had found that if they combine the active agent with a multivalent cation salt, that's chemist speak for a particular excipient that you can combine with the active agent that sort of improved its stability. So we had these other patents, not the active agent patent, and it seemed reasonably broad, that patent covering the active agent. It could be combined with any multivalent cation salt. It was all looking good until a generic company worked out a formulation where they didn't combine a multivalent cation salt with the active agent. So this caused a great dilemma for AstraZeneca because the patent that they had required this multivalent cation salt. Now, something that you need to understand in Australia with the pharmaceutical, the way pharmaceuticals are reimbursed is that the government buys our drugs under the pharmaceutical benefits scheme for a certain price, and that's negotiated, with the patentee at the time that a new drug is ready for market. And so that's a price, and it's a relatively high price because of the costs that it takes to take a drug through clinical trials. It can take 10 to 15 years. It can cost $3 billion to take a drug through clinical trials, and that also cuts into the 20-year patent term. Right? So it's important that these pharmaceutical companies get to make their money back at the end of the term. But what happens when a first generic company enters the market is that there's an automatic price drop to the patentee of 25%. So it's very important for the pharmaceutical companies to stop that 25% price reduction. And they normally do it by getting an injunction based on their patent, right? So the injunction, is an order, against the generic company that they cannot, launch, release, do anything with their product while the injunction is in place. And by doing that, you avoid the 25% price drop. Now, the reason it's important to avoid the 25% price drop is because if you don't do that and you just have your battle, is the patent valid, is it not valid? And in the end, your patent is found to be valid, the price does not get restored. The government continues to pay that low price, even if you're successful. So it's very important to get the injunction. And so here's what AstraZeneca had to do to get the injunction, was they had to argue that this product that the generic was producing fell within the scope of the claims. Now, it turned out that the generic product had a coating, which is a very standard coating in the pharmaceutical field, of ferric oxide. So ferric oxide could be interpreted as being a multivalent cation salt. Now, it wasn't in a mixture with the active agent, but it was part of the formulation. And so a case was put to the court that, this generic product did infringe the patent. Now, when you get an injunction, the court doesn't look at all the issues relating to validity. They just look at it relatively superficially and, is there a case to answer? And it was an arguable case. And so AstraZeneca got the injunction, right, which they needed to stop the generic company from hitting the market. The trouble was when it came to defend that patent, because that actually had to argue that, a ferric oxide coating on a tablet falls within the scope of the claims, that claim was found to be obvious and therefore not patentable. So they ended up losing their patent in the end. So it just shows the strategies at play sort of in the pharmaceutical field. And, you think you've got a nice broad patent, and then, a generic company works out a way to produce a formulation that falls outside the scope of the patent.
I think that case illustrates what I think of as the claim scope paradox. So to be commercially valuable, a claim may need to be broad enough that competitors can't avoid it, like workarounds. But the broader the construction, the more prior art it potentially reads onto, and leads to validity vulnerabilities. But I think even though this is a pharmaceutical example, analogies can be seen across all the other technology patents as well. So what are the strategies for dealing with that, or is more of a staggered approach to filing? Michael, is that right? Do you want to talk about that? Because I think that's some of the things that we look at when evaluating a portfolio of patents. That includes remaining life of the patent itself, but also the family. Sometimes you may want to file continuations or divisional applications, even completely new filings to improvements to versions 2 or 3 of the product. Would you mind elaborating on that point?
Yeah, look, and perhaps we'll start with inventions that come out of universities, which have very early stage work. Perhaps the university team might identify that a particular biological target in the body, if you can find a compound that interacts with that target in the body, it might have a beneficial effect on a disease state, right? So very broad. They've perhaps got a way of sort of perhaps screening, finding molecules that might be useful. They might even have a few molecules that work a little bit, but obviously not a clinical candidate, right? So, that patent might be filed by a university in the hope that they would attract the interest of a pharmaceutical company who then might help them, and they might collaborate, work together to identify new molecules and better molecules, and perhaps do a bit of medicinal chemistry to improve the activity. And so that, you think about that sort of early stage patent filed by the universities. Now, they're very important for the universities, and they allow them to, perhaps get funding money from pharmaceutical companies for that ongoing work. But because they're filed at such an early stage, they're often dead by the time a drug hits the market, right? But so by the time they do all that follow-up work and find the actual molecule, do the clinical trials, that patent, there's not much term left in it, but it's done its job. It's done its job for the university. So then we can go to look at the pharmaceutical company then, when they get their clinical candidate. They obviously file a patent application or to cover that clinical candidate. And if that ends up being the drug on the market, even a very narrow claim just to that single molecule can be extremely valuable, because any generic company would have to use that same molecule, right? But at that stage, the pharmaceutical companies, I guess hedging their bets, you're never sure that first clinical candidate is going to be the one that makes it. So those applications are filed normally with a broad sort of general formula covering, a number of compounds, a class of compounds, right? So, and it may or may not have the actual final clinical candidate in it. It might be filed with the best one they had at the time, but that may not be the patent. That may not be the molecule. So it's filed a bit later, so it's got more of a chance of being enforced when the drug sort of hits the market. Then it might be they come up with a specific molecule, that's not specifically disclosed, and you can get patents for compounds within broad general structures if it hasn't been specifically disclosed, and there's advantages attached to it. So this could be sometimes it's called a selection patent. So you could file that patent, and again, by pushing the filing dates out, you're pushing the expiry date out. And as I mentioned before, patent term is key for the pharmaceutical companies, because they make their most money in those last years of the patent term. So they get the molecule, but then the molecule's no good unless you can actually get it into the human and you can get it to find the dose and find out what it is, what you need to do to be able to treat a disease state with that molecule in a human. So that's where the clinical trials come into play, and where the formulation techniques come in. So it might be that they come up with a sort of a novel and inventive formulation for the drug that allows it to be delivered and get to the site of action. And so they might file a patent on that. And again, that's filed later and it will expire later. And then perhaps even later still, you might have a patent on a dosage regime where they actually, after getting the formulation and through clinical trials, they can work out exactly what dose is needed. And so there could be a patent filed on a dosage regime. They could also end up finding that a particular crystalline form of their active agent is more stable, more amenable for formulation than others, and so they might file a patent on a particular crystalline form. Now, these later expiring patents are valuable because they extend beyond the life of the active agent patent, but they're also more vulnerable to attack. So, more difficult for those patents to meet the patentability requirements. And so you find a lot of those patents are attacked, by the generic companies who are trying to sort of clear the way so that they can produce a generic version. But I guess that's sort of how the strategy plays out, over time, with the aim of trying to push that date out where the first generic company hits the market and they get their price drop.
We certainly do look at the sort of the effective protection term of patents and patent families, and certainly this is one strategy that seems to work for the pharmaceutical space, but I think it also applies to other technology areas. Well, one thing you've mentioned, Michael, that's really interesting also is that there are multiple ways to protect an idea or invention. You talked about the molecules, the drug formulation, the use, dosage, and all of that in relation to just the life cycle of an invention. But that's something that perhaps people are not so I guess aware of. And in the pharmaceutical space, second medical use is another example.
Yeah. So the second medical use is an interesting one because that you could consider that being very valuable, because you've got a drug that's already approved, it's already safe, effective for treating one disease, and through research, you identify that it can be used to treat a completely different disease state, right? And you can get a patent on that, use of a known molecule for treating a disease that it had not been used to treat before, and so you can get a patent on that. Now, the trouble with that, though, is that to be able to market it, get a marketing approval for use in that second disease state, you need to go through a clinical trial process. And even though it's already been shown to be safe and effective, safe, you haven't actually shown yet that it's effective to treat the new disease state. So you need the clinical trials. And there's lots of expense associated with that. And in some cases, you can get the patent, but it's very difficult to enforce that patent, because once medical practitioners find out that if you use this drug that's available on the market for disease 1, and you can use it to treat disease 2, they can just prescribe it sort of off-label, and the price has already dropped on that that known drug, so you don't actually get a new high price to cover off all the expense of the clinical trial that you've had to carry out for the second medical use. So often these second medical use inventions are implemented by the original patent owner, either because they come up with the second medical uses, or they license them in because they can then attach it to their label. But the trouble is, generics, when they hit the market, they can also add it to their label as well, except while that patent's in force. They wouldn't be able to put that on their label.
Yeah, we certainly look at the enforceability matrix of a patent when we evaluate it. And, while process and manufacturing process and method claims are great claims to have, it is difficult sometimes to figure out whether they're actually being infringed in the first place, and then enforcing that. So if you cannot detect infringement and you have trouble enforcing it, then it really discounts the value of those patents, even if it costs a significant amount of money to prosecute and to obtain grant. Process patent is just one thing. Do you want to speak briefly about it?
Yeah, so I mean, you can have patents for processes for making these drugs. You could have a new process that instead of 50 steps to get to the final product, you can do it in 20 steps. So that's a highly valuable process, but that might be difficult to ascertain whether a product on the market has been made using your process. So there's lots of sort of techniques and of identifying signatures in the product, like impurities and things that give away what was used to make it. But it's more difficult in the drug space because they're very pure. They have to be very pure, the drugs that they put in the tablets that we take. But there is a mechanism through the court you know, if you've got some reason to believe that a drug was made using your patented process, you can write to the alleged infringer asking them to confirm, you know, that they're not using the process. And if you're not happy with sort of the replies you're getting, you know, you can involve a court who can, you know, order some preliminary discovery of documents, you know, confirming one way or the other, where the documents are given to a what you call a confidentiality club, people that have signed a confidentiality agreement and can review the process details and, you know, provide advice as to whether it's worth continuing on with an infringement action or not.
Fantastic. Thank you, Michael. Kristen, could we switch to the next slide, please? Just a summary slide. Notice that time has really flown by. We're at the half-hour mark. Thank you so much, Michael. Now we have an opportunity for a few questions. Kristen, if you want to see if anyone's...
Jack, I can jump in. I think it'd be great if you perhaps talk through this this particular slide, and I'll fire in any questions that come through.
Perfect. Thanks, Tim. So we briefly covered through some of Michael's war stories, factors that really drive value in patents and things that we look at when valuing patents. We talked about claim breadth and the design around difficulty. That's essential in knowing exactly what a patent protects and how difficult it is for a competitor to work around it. If it is hard, then the more valuable the patent is. Technical necessity, whether you really need to have this patent in the market, if it's actually something that everybody needs to use. For example, in the perhaps Michael in the pharmaceutical space, if it's you know, a drug that treats or a certain disease and is open to license, and everyone wants to have a share of their license, and that patent becomes extremely valuable. We talked about the remaining life, the economic life, and how you may want to structure the portfolio so that it's a staggered, has a staggered term instead of one-off 20-year filing, because sometimes that's just not enough time to bring an idea, an invention all the way through to commercialization. Enforcement, some of the patents, it really depends on the patent type. You've got the product type patents and the process type patents, and they may serve different purposes. Even though the process patents may be difficult to detect infringement and perhaps have trouble on the enforcement point of view, it may still be valuable from a licensing perspective. It's something that that people are interested in. And finally, the strategic fit. This is one that Michael brought up at the very outset, and that is depending on the type of client, the market position, distribution channels. Sometimes, if a company has a market presence already, and adding a portfolio of patents will really strengthen their core products, then those patents are worth a lot more to the strategic buyer than would be a normal competitor. So that's just a summary slide of our brief discussion so far. Any questions, Tim? Otherwise, I do have another question for you, Michael.
Jack, one that I'll fire in before yours to Michael, and this is perhaps to you first, is Michael's explanation of the different types of patents in pharmaceuticals is very interesting. If you could maybe take that to engineering or another space, and one often gets a perception that if you have a new commercially important technology and there are associated patents, those are in combination going to be valuable. But I guess if you could just give an indication of how one works out whether or not the patents, the quality of protection they provide to that particular technology.
Yeah, thanks, Tim. That's a good question. So So from a pharmaceutical space, there are specific nuances that apply to big pharma and chemistry, but a lot of it actually do carry over to the engineering space, technology, ICT space as well. And that is, when we look at patents, you look at the claim scope. What does it actually cover? You look at the alignment between what's written in the claims and what's protected in the claims and what the client's actually selling into the market. So I mean, that alignment is really critical. If what you have on paper doesn't really cover the product you're selling or the processes you're using, then this clear misalignment means that your patents are not really providing you the protection, because anyone else could be doing what you're doing. So that's clearly one. And also in terms of the filing strategy, that also carries over, because you could do very easily on the mechanical or engineering side, a similar strategy where you have a version 2 of a product or a version 3, and there are improvements around not just the product itself but also the processes, etc. And you would have a strategy that allows you to have a sort of a waterfall effect instead of a 20-year deadline where everything falls over and it's up for grabs essentially.
Great, and a couple of questions came in while you were answering that one. The first from Umesh: can a continuation patent be filed for a mechanical invention, and could it be an improvement of the core invention of a granted patent?
Yes, certainly. So if it's a new filing, so there are two ways to file new applications. One is if it's a continuation or a divisional, that is when the parent application is still pending or before acceptance or registration of the parent application, you can file a divisional application. So Michael mentioned sometimes for investment purposes, you may want to have a narrower claim or a set of narrow claims granted first, and you can show your investor that, hey, look, these patents have been examined and they're granted to show your technical advantage. But then at the same time, before grant of those applications, you file divisionals or continuations, so that you could have another crack at a broader claim with a bit more time up your sleeve. Additionally, if you've sort of passed the deadline to file continuations or divisionals, you could file certainly new applications to improvements for sure, if those improvements are novel and inventive. So what that means is the improvements have not been disclosed in your earlier filings, and that they are not considered to be obvious in view of your earlier disclosure. So that goes actually back to one trick, is that when you're filing your original application, you don't really want to anticipate too much in advance. You might think, okay, all right, I want to throw everything kitchen sink into the specification, but if by doing that, you may only obtain, one patent grant for the original idea, but what it means is that you've actually disclosed too much and restricted your ability to protect the second and the third version. So that's one trick when it comes to patents, is that disclose only what you need to protect that first invention, and then that leaves you space for improvement filings.
Okay, another question from Craig. I think this relates to a point you made, Michael, saying, does filing two provisional applications with broader and narrower claims raise an issue under the Paris Convention for claiming priority from the first filed patent application?
Yeah, that's a good question. I love the Paris Convention, as Jack knows. So yes, if you file them on the same day, who's to say which one's the first? Right, they're both the first, would be how I would answer that. And there's very, very little case law around the world on the Paris Convention and what's acceptable and what's not acceptable. But I think it's arguable, strongly arguable, that they can both be considered the first, and you can decide which of the firsts you run with for your PCT. And I'm not aware of any court that disagreed with that or even considered that yet. So
Michael,
it's safe
yeah,
process.
by the way, Michael is the resident expert on Article 4C4. So yeah, that's a fantastic question on priorities.
And a question from a former colleague of mine, Tim Mahood, so thanks for that. He's saying relate factors 4 and 5 on the chart and asking what assessments we typically undertake in looking at enforcement and strategic power.
Great question.
Probably for you, Jack.
Yeah, thanks, Tim. So clearly it's one of those things that we will assess depending on the portfolio. It comes down goes back to technical, commercial, and legal analysis we look at when assessing valuation of patents. If it's, say process claim, process patent, we look at it and go, okay, well, given what we've talked about from a litigation and enforcement perspective, discounts are likely for its value. And strategic fit, for example, if we know that the patentee or the client has the distribution capability expanding into various markets, then that certainly is a bonus. But also if we can identify during the commercial evaluation that there are significant market players that could be licensees, and that really opens up sort of the door as well in relation to what that patent may be worth. So a lot of this these are great questions, and a lot of these factors we do consider during the valuation process.
Another question from Craig Ruffell, also focusing on the chart, but columns 1 and 2, and asking for us to explain the difference between 1 and 2, claim breadth versus technical necessity.
Great. Okay, so claim breadth, that's how narrow or broad a claim is. So if you think, take a bicycle, for example, if you've got a patent claim towards the bicycle, if you have front wheel, a rear wheel, a frame, some pedals and a handlebar, and your claim, you also added a bell, for example, and that would constitute a very narrow claim, because a competitor could actually then create the same product without the bell, and they'll get around it. So it's essentially a measure of how broad or narrow your patent protection is. The second point about technical necessity is, if you think about standards like the 5G standards or the Wi-Fi standards, where everyone's gone, jumped on board and wanting to use this technology, if you want to then improve upon it, or to be a licensee, to be, as part of the technology phase, then those patents involved in that standards are going to be far more valuable than patents that people are not using or could avoid or and opt out. So when you create a necessity from the technical point of view that everybody has to use what you've designed because it is the best way to do it, or because the standards have adopted this, then that's a perfect place to be. It's a fantastic position. So that's sort of the difference. One is more legal around the breadth of the claim and the scope of protection. The other is really around the technical need for everyone to be using your technology.
Great. Well, just as we try and do the FAST30 and the FAST15 questions, it's probably time to wrap up. So Michael, thank you very much indeed, and thank you, Jack. That was a great discussion. And if anyone has questions, please keep firing them, and we can answer them afterwards. It is worth saying that our next webinar will be on the 7th of May, and the topic is how branding builds value and drives growth. And it'll be another joint presentation where I'll be joined by Charlie Rose, a brand strategist from Principles, And once again, we'll marry up different lenses, both the strategy lens and the quantification lens. So thank you very much for joining us today, and we'll keep you informed of future webinars. Thanks very much.
Thank you.
Bye-bye.
Thanks, everyone. Thank you for your time.
Thanks a lot.